Janki welcoming you to Procure Evolve. In this video, we are going to discuss a couple of very important terminology used in the contracts. Now to understand these terminologies, let us take a case scenario. Let us assume that there is an employer who awards an EPC contract to a main contractor. Now this main contractor, in order to fulfill his obligations under this EPC contract, places another order on a subcontractor to procure certain critical components. So now there are two contracts. One contract between the employer and the main contractor, that is EPC contract, and the another contract is between this main contractor and a subcontractor. Now both the contracts has certain provisions to assign the benefits and rights to different parties involved in the contract chain. So now during the execution process of the contract, there were some glitches in these critical components supplied by the subcontractor and put into operation under the facility of the employer. So now the employer found some material breach in the performance of these critical components and terminates the contract with the main contractor. The employer asked the main contractor to assign the subcontract the main contractor had with the subcontractor to the employer. So after certain negotiations and discussions, the main contractor agrees and writes to both the parties, that is the employer as well as the subcontractor, in order to assign the subcontract to the employer. This main contractor thinks that they are now out of this loop, but after certain time period, the employer gets a notice issued to the main contractor claiming a huge amount. This actually is a case which was heard in the court of London. So this main contractor receives a claim of 133 million pounds. So in order to defend their stand, they submit to the court that the termination of the contract by the employer was due to some defects in the components, critical components supplied by the subcontractor. And on the request of the employer, they have already assigned their subcontract with the subcontractor to the employer. Now why they should have this claim, why they should absorb this claim, rather they should be absolved from their responsibilities. So while hearing this case, the court found that there was an assignment of benefits by the contractor, main contractor, to the employer, but the main contractor still remains liable for the financial damages incurred by the employer. Now why court has given this kind of judgment? And while giving this kind of judgment, court has spelled out clear-cut differences between the assignment and novation of the contract. Now let us try to understand these two terminologies. So in order to understand this, we have to understand the basic structure of the contract. So in any contract, there are certain benefits and certain rights, as well as there are certain obligations and there are certain liabilities. So in assignment, only the rights and benefits can be assigned by one party to another party involved in the contract chain, or these benefits and rights can also be assigned to a third party who are not explicitly mentioned in the contract or in the contract chain, but the liability remains with the assigner. The assignee will enjoy the benefits and the rights, but the liability remains with the assigner. This is what is the concept of assignment clause in the contractual terminology. Now when we talk about novation, novation is a bit different. In novation agreement, when the contracts are modified under the novation provision, the rights, benefits as well as responsibility and obligations are transferred by one party to the another party. So in other words, one party is getting replaced by another party under the provision of novation. To summarize this two, in the assignment, the benefits and the rights are getting transferred by the assigner to the assignee, but the legal responsibility and the obligation still remains with the assigner. Whereas in novation, the party who novates the agreement to the new party, that new party becomes responsible for benefits as well as rights as well as responsibility and the obligations. So in a way, the novation agreement replaces one party with the another party completely. Whereas in assignment clause, the assigner is getting partially replaced, that too in terms of benefits and rights. So in this case study which we have discussed, the court clearly stated, while transferring the rights and benefits of this subcontract with the subcontractor to employer, employer can enjoy the benefits and the rights to get certain work done from the subcontractor, but at the same time the contractor, the main contractor, still remains responsible for the damages that have been incurred by the employer. Now another crucial aspect, while entering into or while giving notice about the assignment, the contractor should very categorically mention as to when benefits and the rights are getting transferred, what is the cutoff point. That is, when assignee becomes and enjoys the rights and benefits, that benefits and rights they can enjoy only after this assignment is triggered. But whatever benefits and rights accrued before this assignment is enacted, whether should it remain with the assigner or it should also get passed on to the assignee. If there is no categorically mention of this point, automatically the accrued benefits as well as the benefits, that is subsequent benefits after the assignment is triggered, gets passed on to the assignee. While entering into novation agreement, there can be a replacement of party as well as modification of terms and conditions. But one more crucial point which needs to be paid due attention and should be addressed very categorically is, there should not be any breach of contract when the contract is getting, the point when the contract is getting novated. So while entering into novation agreement, there should not be any material breach or any sort of breach in the contract. So these are the basic differences between novation and the assignment clause in the contract. These are very important clauses. At times the lenders of the project, they want certain terminology to be specified, certain draft of the assignment clause and the novation provisions they want in the contracts. So while drafting the contract, one needs to be very particular about the language and the choice between novation and assignment. If one fails to do so, there can be a catastrophic impact on your business and the project. If you have any specific query, please do write to us. Our contacts are already provided in this video as well as in the description box. Have a great time. Goodbye.